Hello, everyone. Gary Savine here from Savine Employment Law. Thank you for joining us this morning or this afternoon, depending on where you are. This is our inaugural episode for our new Do It Now series, focusing this time on the FTC ban on non-competes. I'm going to get started. I want to respect everyone's time and our time limit. We're going to be meeting for about 30 minutes, 15 minutes of presentation, and then we're going to leave time for questions. So our Do It Now series is part of a new way of supporting our clients and friends. We want to help everyone focus on pressing matters that your business should be focusing on now. And we're pairing it with strategy sessions, an offer of strategy sessions with Savine Employment Law lawyers to hold you accountable to act on these priorities. So the FTC ban on non-competes is our first presentation, and you'll see that we've slated other presentations over the coming months to keep you focused and to keep your business compliant. For HR professionals who are in the audience, we are also providing SHRM recertification credit. We will provide that code at the end of the session, so stick around for that, as well as for some other resources. And briefly, for those unfamiliar with our firm, I am Gary Savine. I founded Savine Employment Law in 2012. We're an advisory and litigation defense firm focused on serving the employment law needs of employers and the executives who run them. We focus on compliance services, litigation defense, and internal investigations, clearing the way for employers to manage their workforce profitably. We also provide some ancillary executive legal services to help executives manage their career ROI and navigate legal obstacles that can end their careers. Before we begin, though, I'd like to offer a couple of disclaimers. First, a correction. Some of you might have received emails that contained a term that we mistakenly inserted in the emails. We had referred in a couple of our emails to our lawyers as experts. I just want to call out the rules of professional conduct governing us as lawyers here in Illinois prohibit us from using that term. So we wanted to call that out, that we've made that correction, and we apologize for any confusion it might have caused. In addition, for those of you who've watched legal updates by this firm or others, we've always offered the disclaimer that this webinar is for educational purposes only. It does not constitute legal advice. It should never be relied on as a substitute for professional legal advice tailored to your specific circumstances. And as I mentioned at the opening, we are offering strategy sessions for you to engage us to tailor our advice to your circumstances. So let's talk about the agenda really quickly. Pretty simple and straightforward. We're going to talk about the ban that the FTC has announced. This broad ban on non-competes, what it means, what it doesn't mean, when it will apply, and how it will impact businesses. We'll also talk about what will happen and what you should be focused on, even if a court decides to block this rule. You might have read in the press that there are already a couple of pending court challenges, and it might be causing some employers to be complacent and think, well, there's nothing really for us to do right now. We'll just sit and wait it out and wait and see. Well, we're here to offer a gentle prompt and warning that that is not the case. That this announcement has set with certain forces in motion that demand a response of your business. And that will lead us into what we believe you should do now. There are specific actions that prudent business owners and HR professionals should take now. We'll call those out and describe how a lawyer can assist you with that. And then we'll open it up for Q&A. So let's start and get a baseline for what a non-compete is. And I should mention, while we're proceeding, feel free to drop your question in the Q&A field. Those questions will accumulate, and when I get to the Q&A portion of the presentation, I will go through those questions one by one. So no need to hold back your questions, put them in the chat, but just be aware I'm going to let those accumulate while I proceed. So let's make sure we all have a basic understanding of what a non-compete is. And you'll see in these slides, I use the acronym NCP for short. A non-compete is essentially a contractual obligation to not compete against your former employer for a specified period of time after leaving employment. And historically, it's been used to promote and protect certain things like trade secrets and customer relationships and goodwill. And it's also meant to incentivize employers to invest in the specialized training of their workers. Employers want to feel safe that if they're going to invest in their worker skill sets, that they won't need to worry about that investment being poached by a competitor. But why a ban? These, as many of you know, non-competes have been respected by courts and used by the business community for quite a long time. Why a ban now? Well, I think it's important for those of you who've never been involved in non-compete litigation to know that historically, actually, most states and their courts have disfavored non-competes and view them as burdensome to workers. And as a consequence, courts have traditionally limited the enforcement of non-competes. Regardless of what a non-compete agreement states, if an employer wants to enforce it, historically and in most states, employers have had to show and prove to a court that they had a legitimate business interest for imposing it, and that the non-compete itself in this employee's particular circumstance was reasonable in duration and scope to serve that business interest. But until recently, the law hasn't imposed any penalties on employers for maintaining or enforcing unenforceable non-competes. Employers could simply go to court, seek enforcement of a non-compete, and if they lost, but they weren't penalized. And as a result, this has incentivized over the years many employers to blanket their workforce with non-competes without giving much regard to the scope of the non-compete or its enforceability. And as a result, many believe that has had negative impacts on the economy. It's depressed wages for some by locking them into jobs that prevented them from upward mobility to positions of higher pay elsewhere. That many believe that it's also worsened the gender wage gap and exposed workers to wage theft, and it's locked some workers into toxic and harassing work environments. So those forces or those trends have created momentum for bans. So that brings us to the FTC's announcement. The FTC's final rule, which barring a court injunction or rescission, will be effective September 4th of 2024, bans, with some exceptions that we'll get into in a moment, non-competes. And non-competes can mean quite a few things in this regard. A non-compete could be what I mentioned, is just a straightforward non-compete that on its face is clearly a non-compete. But the ban could also cover other agreements or arrangements that an employer has put in place with its workers, depending on the impact that they have on a worker's mobility and ability to work elsewhere. So a no solicitation obligation or an NDA, or even a policy that's never been reduced to a contract that prohibits competition, those under the rule could be deemed non-competes if, as the FTC puts it, they are so broad and onerous that it has the same functional effect as a non-compete. And the FTC has also been clear in its rule that this rule will apply broadly, not only to agreements or arrangements with W-2 employees, but also to independent contractors and sole proprietor businesses that an employer might engage, or even unpaid volunteers, interns, externs, or apprentices. But there are exceptions. The FTC has attempted to strike a balance, and these exceptions were defined based on extensive input from the business community during the proposed rule phase. The exceptions include they're not, or I'll put it another way, the FTC has made clear that they will not go after what they refer to as established means to protect proprietary and sensitive information. And you might sense a little bit of double speak here. They've called out that they won't go after NDAs or non-solicitation clauses or other terms that might hold an employee in place. But they reiterate that these will only not be challenged unless they are so broad and onerous that they have the functional effect of a non-compete. And I should mention here that the FTC did not define a standard for how it would determine that an arrangement has the impact or the functional effect of a non-compete. The FTC has stated that they'll evaluate that on a case-by-case basis, similar to the way a court would evaluate a non-compete. Courts never take a blanket approach to non-competes. They always evaluate non-competes on a case-by-case basis. Other exceptions that the FTC has mentioned, they will not challenge non-competes that are part of the sale of a business or are in a franchise or franchisee relationship. They've also excluded some nonprofits and entities outside of the FTC's jurisdiction. Some entities outside of the FTC's jurisdiction include financial institutions and banks. And most importantly, the FTC has exempted or excluded existing non-competes with senior executives. And when I say existing non-competes, I mean non-competes that were executed and put in place predating the publication of the final rule. And the final rule was published just about a month ago. So and senior executives are defined as policymakers. They have to have policy-making authority. And there's a standard for defining what a policymaker is. And also they have to have made no less than $151,164 in the preceding year. The FTC was also careful to note that an employer cannot get around or expand this exception, if you will, by amending or extending an existing agreement to continue beyond its natural expiration date. So what happens if the rule goes into effect? Well, actually, certain things have to occur, or employers have certain obligations that they must meet before the rule goes into effect. Prior to the effective date, employers must provide written notice to current and former workers. This notice has to contain a variety of things. In essence, the notice must inform workers who are under non-competes that their non-compete is unenforceable and will not be enforced. And the FTC was kind enough to provide model language that can be used by employers. Beyond that, the FTC also will require employers, as of the effective date, to stop enforcing existing non-competes and to not issue new ones. Now, stop enforcing existing non-competes simply means that you can't enforce it. It does not mean that you, as an employer, must go out and rescind or amend employment agreements that already have non-competes in it. The FTC understood that that would be too much of a burden on employers, and it would just upset the apple cart too much to require employers to open existing employment agreements and renegotiate them in order to extract non-competes that violate the rule. So will the courts block the ban? Your guess is as good as mine. There were a couple of lawsuits filed immediately after the final rule was published, but time will tell whether or not any court will accept the challenge or issue an injunction. But let's assume that it does issue an injunction and blocks it. I think it's important for business owners and HR professionals to recognize that the mere announcement of this rule has already set certain wheels in motion that require you to act now. Many workers believe that the ban is already in effect. They don't understand the nuance between a proposed rule and a final rule and effective date. We're seeing it already. Our clients are experiencing workers who've left and are declaring that they are no longer shackled to a non-compete. And some workers are emboldened by this and are taking trade secrets with them. They're poaching customers, they're poaching information, and they're wreaking havoc. So there's reason to act on that for that reason alone. Additionally, the workers who've been under non-competes and have felt that those non-competes have locked them into unacceptable working conditions that they view toxic, or have perhaps forced them to keep jobs where they weren't paid what they were promised. Their belief that this ban is already in effect is prompting workers to begin leaving those types of jobs and engaging or consulting with plaintiffs' lawyers to evaluate the opportunities for lawsuits and wage actions to sue for anything from employment discrimination to the claims for unpaid wages. We're also seeing it, though, at the executive levels, the way that employers are recruiting employees. It's affecting negotiations and influencing what employers are offering and what employees are willing to accept for purposes of serving the same ends that a non-compete would serve without the non-compete. But beyond those practical impacts of the announcement, as I put it, the wheels that have already been put into motion, this rule has highlighted for many something that they didn't already know, that there already are restrictions on Illinois employers around non-competes that might have already rendered the non-competes that they have ineffective, void, and perhaps unlawful. One of these laws is the Illinois Freedom to Work Act amendments of 2022. These amendments apply to agreements that have been entered post the effective date of the amendments and require that certain requirements be met for a non-compete to not only be enforceable, but for it to be lawful. For instance, just to be a little more specific than what the slide provides, the amendments prohibit non-competes entered into with employees who make less than $75,000 a year, and non-solicitation agreements with employees who make less than $45,000 a year. And it also, as you can see, requires additional written terms in the agreement to be lawful, and it imposes its own standard for courts to use to judge enforceability. And the significant thing to understand about these amendments is that these amendments provide employees or workers and the Attorney General of Illinois to sue employers for non-compliance. So gone are the days where an employer could just impose a non-compete regardless of its enforceability and not be penalized. Now, the Attorney General of Illinois is looking for employers who are using non-competes that don't meet these requirements and taking legal action against them. In addition, plaintiffs' lawyers are now making it part of their evaluation process when workers come to them to evaluate whether they have claims. The plaintiffs' lawyers are now making it a matter of course to ask them to allow the lawyer to review their non-compete to see if it's violated this law, and it gives them the ability to sue. And if they sue, they not only collect their damages, but they also collect their attorney's fees, which is giving plaintiffs' lawyers the incentive to pursue these claims. And you might have also heard that the National Labor Relations Board last year its general counsel announced that it considers the use of non-competes in employment an unfair labor practice, except in undefined and vague limited circumstances. The NLRB is an agency that you might be familiar with as enforcing the laws that regulate relations between workers, workers, and their unions. But it's actually broader than that. Any worker can bring a claim, or pursue an unfair labor practice. And the NLRB's general counsel has instructed its field offices across the country to look for employers who are using non-competes are applying non-competes to any non-supervisory worker so that the NLRB, the field office can file unfair labor practice charges against employers. And like claims under that Illinois law, an unfair labor practice can result in monetary penalties and liability for an employer who violates the rule. So what should you do now before I get into the Q&A? Hopefully some of this is already obvious, but if it's not, I think it bears repeating. You should ask a lawyer to review your agreements and your policies. Anything that imposes any sort of a restriction or an obligation that would extend beyond employment is fair game for any of these rules, the FTC rule included. Ask your lawyer to review it and to propose edits and modifications to conform to these new rules. At the same time, you should have a lawyer help you and your business assess the legal risks that your existing non-competes might already have created. Like I said, these non-competes are unshackling workers, or this announcement of the rule is unshackling workers who believe that non-competes are now banned. It's prompting them to go to attorneys to evaluate whether they have claims for harassment, discrimination, wage theft. It's also prompting them to violate the terms of the non-compete and steal trade secrets. It's important for you to have an educated ear and sounding board help you evaluate the legal risks that this situation might have already created for your business and to address them. Bigger picture, though, and looking forward, you should talk to your lawyer about how best to tailor your policies, practices, and agreements to your unique situation to protect your business from unfair competition lawfully and cost effectively. So that's your task. These are your priorities right now as a result of not only the FTC's announcement, but as a result of the NLRB's attorney, general counsel's pronouncement in 2023 and recent amendments to Illinois law in 2022. It's incumbent upon you and your organizations to get your heads around the situation, assess the risks that it poses to your business, and to take action. And we're here to help. We have created a flat fee non-compete strategy session that we are rolling out at the same time as I'm giving this presentation. You can use this QR code if you wish to register. Space is limited. We've already begun announcing it to some of our clients who are taking us up on the offer. And we'll be covering the items that I described to you. And if I'm ready, I'm going to also put in the chat here a link to this registration page for strategy sessions if you wish to get on the list and get your flat fee strategy session scheduled so that you can start planning now while there's still time to react. I'm also providing now the SHRM code for anyone who is seeking SHRM recertification credit. So that's now in the chat. So with that, that's our presentation. I'm going to turn to Q&A now, and I see a few questions in the queue. So I'll bring those up, and we'll end right sharply at 12:30 as promised. So someone asked, if you earn more than $151,000, does this rule apply? Hopefully I've addressed that question a moment ago, but I'm going to go back to the slide where I discussed it. Give me just a second while I bring the slides back up. Give me just a second. There is an exception, as I mentioned, for senior executives, but there's an important caveat that the senior executives, the agreement with the senior executive must predate the publication of the final rule. If the agreement doesn't predate the publication of the final rule, and if the senior executive doesn't meet this $151,164 salary threshold and doesn't have policymaking authority, the exception doesn't apply. I'm going to stop sharing and take some more questions. Give me just a moment. Someone asked if these federal cases, if a federal case is upheld to strike down or to impose an injunction preventing this final rule from going into effect, can states move forward to try and circumvent? I think what would happen is, well, there are a lot of moving parts here, but as I mentioned, this is something that's being addressed on both the federal and state level. Illinois is a great example. California has rules in place around non-competes. New York, there's been attempts to legislate non-competes as well, and a number of other states have restrictions. And what we're seeing is it's happening on both sides of the coin. So if this rule doesn't go into effect, we expect to see more activity at the state level across other states. Might also impact what the extent to which Illinois already regulates non-competes. But I don't believe that the states would circumvent these lawsuits and somehow have any power to resuscitate the FTC rule. But like I said, we're a long way from this FTC final rule from being stricken or being enjoined or blocked by a court. So we're recommending that everyone operate on the assumption that the FTC rule is going into effect. And like I said, it really doesn't matter whether the FTC rule goes into effect or not in terms of defining your current priorities, because it's set in motion forces that require your attention now, and there are already rules, the NLRB's pronouncement and Illinois law, that really require you to pay attention and start managing your non-compete practices more carefully. We've got a couple more minutes. I'm going to see what other questions are in the queue. Someone asked, what is an example of a training repayment provision that would be legal, and are these dependent on income level? Training repayment provisions tend to kick in, are arrangements that require employees to pay back certain costs if they certain investments in their training, if they leave within a certain specified time after they're hired. And as you can imagine, that can serve to shackle an employee to their job. So the question is, does it depend on income level? I think it depends on a lot of factors. Income level would probably be one. The courts the FTC, if you were just looking at it narrowly from an FTC perspective, the FTC is going to apply that standard I mentioned. Does it have the functional effect of a non-compete, meaning it restricts a worker from working for a competitor? And that's a case-by-case analysis. It's going to depend on the facts. And I suspect that the FTC, if they're applying this rationally, will consider income level. Someone asks, are the monetary penalties dischargeable in bankruptcy? If it's a corporation, can the business shareholders have personal liability? Well, I'm not a bankruptcy lawyer. I can certainly refer you to a good one, but I don't know what I can't answer the bankruptcy question for you. Can business shareholders have personal liability? I suppose that would also depend on the facts. The FTC rule applies to businesses that it regulates, and I suppose if the business is a sham and a court could pierce the corporate veil, there's a potential for individual liability, but I think that's speculative on my part. I can't say for sure. Let me see if there are any other questions in the queue. Someone asked, will I be circulating the slides to the attendees? Yes, I will. We're going to be circulating both the slides and this recording, as well as additional resources. And that brings me to the end of our questions, and it is 12:29, so I'm going to end the presentation here. Thank you very much, everyone, for attending. I hope you enjoyed the presentation. If you need the SHRM code, please look at the chat. We've provided the SHRM code. We've also provided an additional link to register for a strategy session if you'd like a strategy session. And one more thing, as I mentioned, we do provide some ancillary services to executives. So if you're an executive and you wish for a strategy session to address your circumstances as an executive, we can arrange that on a flat fee basis as well. So thanks, everyone. And I hope you tune in for our next presentation, where we will be talking about state and local leave laws that are going into effect this summer. Thanks, everyone.